30th. So this is the last part of the FDA in court on ivermectin hearings. This is an appeal that is going on. So let's look at it. My summary of today's part is that number one, FDA said to court that you cannot fact check our scientific views. Second thing they said was that the third parties, when court challenged them to say that third parties may have gotten your messages or referenced or cited you to prohibit use of ivermectin or make such decisions, FDA said these are independent, sophisticated scientific third parties. We do not control them. The third thing that was interesting was that the FDA's lawyer said, so the statement, why you should not use ivermectin, or you're not a horse, you're not a cow, you all stop it. So she said that even if a part of these statements is, and I'll read through them, the actual, this is just my paraphrasing, even if that one part of the statement is found illegal, the remaining statement is still available. So to me, it seems like if somebody said to another person to go to the bank and rob it, and that person robs it, and then they both are caught, and this person who said it simply says, well, if you remove the words rob it, then the remaining statement is available and it's fine. And finally, the question from the appellant's lawyer, or the comment that Supreme Court has said, and again I'm paraphrasing, will read the actual message or the wording, that Supreme Court has said that government agencies could end up just raising their eyebrows and causing reactions from third parties. So in that case, it seems like they are responsible. But anyways, let's see. Let's hear the actual words instead of what I think. And I'm not a lawyer, so my understanding is kind of not the best anyways. So let's start. This is the video. This is 240802 Apter versus Department of Health and Human Services, August 8, 2023, U.S. Court of Appeals for the Fifth Circuit. And this is what we are going over. To see the transcript that I copied as well, what you do is go to these three dots here and say show transcript. And this transcript would show up, and I have been copying it and doing whatever spell checks I could do or corrections I could do. But again, this is an AI generated transcript. There have been, in today's talk, you would see that there are some parts where the audio was too muffled and the AI had done a very incorrect translation or transcription. So I tried to make sense of it. I may be wrong as well. And so let's start. So this is part 3, time 33:42. FDA, so if you look at yesterday where we closed, FDA said, but the next sentence in that statement says, no, you should not. So judge had said to FDA that your statements do not have all the caveats, the caveats that FDA was presenting, that we should be able to say it in this case or that case. And then the FDA said, but the next sentence in that statement says, no, you should not take any drug unless they've been prescribed to you by your doctor. And just to take a step back this course, so we had gone this far. Interestingly, for yesterday, we saw that FDA said that doctor has the authority to prescribe ivermectin for COVID. It is doctor's authority. It is not our authority. And I was still finding out that people are still fighting to say FDA never said that. So this transcript from yesterday, please look it up. And FDA said that doctor has the authority. Here, FDA is clearly acknowledging that doctors have the authority to prescribe human ivermectin to treat COVID, so they are not interfering with the authority of doctors to prescribe drugs or to practice medicine. This is at minute 31, second 26, FDA's lawyer to the court in this appellate court case. FDA, I'm going to repeat it. FDA is clearly acknowledging that doctors have the authority to prescribe human ivermectin to treat COVID. So I wanted to finish that one discussion. Now, this doesn't mean that FDA is saying that the ivermectin is good for COVID or ivermectin is bad for COVID. They are simply saying, we acknowledge that it is a doctor's authority and not ours. We are not practicing medicine. We are not interfering with them. So anyone who keeps saying that no, FDA has said it is bad, yeah, sure, they still have that opinion that it is bad. But they are saying here in the court that we are not stopping anyone from prescribing it. And we realize and recognize that it is the authority of the doctor. So with that clarity, it's in the transcript. Part 3, FDA. And just to take a step back, this court is explained in Danos versus Johns that even assuming the ultravirus, this not a correct spelling here, exception to sovereign immunity is still viable. There is a very high bar for invoking this exception. So they're saying, I think I'm paraphrasing, I'm not a lawyer. What they're saying is that we have this sovereign immunity, and if you want to create an exception to that, you have a very high bar to meet. Plaintiffs must show that the agency was acting without any authority whatsoever or without any colorable basis for authority, and given plaintiffs' concessions about what it is proper for FDA to say about the informational statements about what ivermectin is, FDA approved for, what it's not FDA approved for, and that it's appropriate for FDA to notify the public about consumers getting sick. So here they're saying it doesn't matter that what we said, we had the sovereign immunity on that or not. If you said there was an exception that we didn't have the authority to say this, it was our duty to tell the consumers what ivermectin is approved for or not, and what is appropriate. They said we have a right to talk with the people. And then they continue, this is far from, and I have taken this transcript, so I'm not making up this story as some people were commenting. This is far from meeting the very demanding standard for the ultra various exception. Again, this is wrong transcription. I do not know the exact words. I'll go and see it later on. The fact that we are even talking about specific statutory authority for FDA to make these statements show that, of course, FDA did have a colorable basis for its authority. So they said we had a basis, colorable basis, whatever was the circumstances, and then when we said it, we had the authority to say it. Judge, could we? And then they said, I have 2 questions. The first one is, if we were to determine that the district court erred regarding sovereign immunity, should we remand the district court in the first instance to deal with standing, or should we address standing? So I think, again, I'm not a lawyer, but I think what they're saying is that district court, who had rejected this case by saying that FDA has sovereign immunity, so the judge here is saying, did they make an error that you have the sovereign immunity, and should we remand it, or should we address it on the basis of standing here? That's the first question. You go ahead and I'll ask the second one second. FDA says, Your Honor, standing is a legal question that this court can address in the first instance, so there is no requirement that the court remand it to the district court. But of course, the court could remand to the district court if it preferred. Judge, the opposing counsel cited the Alliance case regarding standing. Do you have anything to add to that? FDA. Yes, Your Honor. As we explained in our 28J letter, the Alliance decision was, first of all, the Alliance decision, first of all, it's non-presidential. It was overridden by Supreme Court. But even on its own, so FDA lawyer reached that far, and judge said, it's what? An FDA lawyer said, it was overridden by Supreme Court. stay and it's non-precedential. Judge said overridden by Supreme Court. Okay, thank you. It is, and even I didn't. I'm sorry, I just didn't understand what you were saying, so I got it. FDA lawyer then says, and even on its own terms, the reasoning of that decision does not support standing here. The Alliance panel concluded that the plaintiff doctors had standing on the grounds that FDA's action caused those plaintiff doctors to treat certain patients in ways that resulted in harm to the doctors. But here, plaintiffs have not alleged that FDA statements forced them to provide medical care in ways that harmed them. Both the allegations in the, and then judge said, okay, so you think that they didn't allege that the FDA statement caused them a problem. FDA. Plaintiffs have not alleged that FDA statement forced them to provide medical care in a way that harmed the doctors. The allegations in the complaint, and the judge said, you don't disagree that Dr. Bowen suffered reputational injury. I think that is Bowden. FDA, no, we don't. So FDA said, no, we don't think that they suffered. Judge, or that Dr. Bowden and Dr. Marek suffered economic injury from losing their jobs. You don't dispute the fact of their injuries, do you? To which FDA said, no, the government is not disputing injury. In fact, in those examples, but those injuries are not traceable to FDA statements. So they said, we agree that they were injured, economic injury, but that's not traceable to us. You can't prove that we did something. So those injuries are not traceable to the FDA statements or redressable by an order declaring FDA statements unlawful, even if this court concluded that parts. So now what they're saying is, even if you said that parts of the statements are wrong, that still doesn't mean the remaining statement is able to bring that traceability to us. Very interesting. So FDA says, no, the government is not disputing injury, in fact, in those examples. But those injuries are not traceable to the FDA statements or redressable by an order declaring FDA statements unlawful, even if this court concludes that the parts of the statement that said stop it or should or no were unlawful. The remaining parts of the statements that merely provide information would still be available. This is where I feel that if somebody said, you go to the bank and rob it, and then something goes wrong, they rob the bank, and these people are caught, and the statement maker says, well, if you remove the words rob it, the remaining statement is fine. So listen to this again. Even if this court concluded that the parts of the statement that said stop it or should or no were unlawful, the remaining parts of the statements that merely provide information would still be available. And plaintiffs have not shown that it's likely that these third parties would rescind their actions that harm the plaintiffs. Isn't that interesting? They're saying, even if you said our statements are wrong, that doesn't mean that the third parties that took action would change their action. It is a very interesting dialogue here that FDA is saying we are actually not responsible for whatever happened. And these third parties took their action. They are scientific organizations. They took an action on their own. So judge said, well, I do still have that one question, but I have another question now. So when you said it's not traceable or redressable, once the FDA has become aware, check this out, this is a very interesting one. Judges are smart in this. Once the FDA has become aware that courts around the country are relying on the FDA to keep hospitals from allowing doctors who have privileges there from prescribing these drugs, and also aware that major pharmacies are refusing to fulfill these prescriptions based upon the FDA statements. And so it becomes aware, it being FDA here, of that it is allegedly interfering with the doctor patient. Does the FDA have an obligation to speak again to clarify things so that people are not relying upon the FDA statements in this doctor patient relationships? That's one question. That's a very interesting question. They're saying to FDA that fine, you are saying that you made these statements and you are not saying that you were coloring anyone or biasing anyone or ordering anyone or commanding anyone. So then now that you have become aware, or if you became aware that the courts around the country are stopping hospitals from allowing are are letting the hospitals to stop doctors from prescribing ivermectin, or the CVS's and Walgreens, these are refusing to fill ivermectin. If you became aware, would you like to then clear this up? Because they're doing it because of your statements. So read this question again. Once the FDA has become aware that courts around the country are relying on the FDA to keep hospitals from allowing doctors who have privileges there from prescribing these drugs, and also aware that major pharmacies are refusing to fill these prescriptions based upon the FDA statements. And so it becomes aware of that. It is allegedly interfering with the doctor patient. Does the FDA have an obligation to speak again to clarify things so that people are not relying upon the FDA statements in these doctor patient relationships? That's one question. FDA says, no, Your Honor. Those pharmacies and those hospitals are sophisticated, independent third parties who are not controlled by the FDA. So FDA said, sorry, no, we cannot do that. They did it on their own. We are not going to clarify. Now they're having to clarify in the court. But when the court said, would you clear this up? They said, no. So judge says, but the courts are saying the FDA is why we are not going to order the hospital to let the doctors give the prescription. So the judge said, well, the courts are using your statements. FDA says, I'm not sure which court decision. Judge says, there is 5 or 6 of them, and it sometimes cites other health groups as well as the FDA. It's not just the FDA, it is whole, but the FDA is prominently featured, usually first in these opinions. They are cited at length in the briefing, but that's okay if you don't know. When we'll just move on to the next question. So this is a very interesting one. Couple of things that came across, we just saw. Number one, FDA simply saying, even if you find part of the statements illegal, remove those parts and the rest is still fine. And the second one, when court said, would you clarify this situation? They said, no. We have nothing to do with this situation. These third parties are sophisticated organizations. They're doing it on their own. So then at 3929, FDA continues, as Your Honor noted, there are many other scientific organizations who have made these statements about ivermectin in tradition to the FDA. Now, FDA science is becoming very clear. If you have any doubt about how FDA looks at the science, I would request you to look at the part 1 of this talk, where they were trying to present what their science is, and there was no science. So I hope that other organizations don't take this as a badge of honor when FDA says they are scientific as well. So then 3937, FDA says, and I'd like to point the court to page 1149 of the record on appeal. So one of the plaintiffs, Dr. Maddock, alleges that he was forced to resign from his position at Centora Norfolk General Hospital for promoting ivermectin as well as other drugs. But the statements from Centura telling its hospitals to stop prescribing ivermectin, these cite statement from other scientific organization in addition to the FDA. So they're saying, oh well, Centura was citing other organizations too, not just the FDA. And because all those statements are available, plaintiffs have not shown that the injuries caused by third parties are traceable to the FDA or redressable by an order declaring these FDA statements unlawful. So they can't be traced to us. And even if you said some part is unlawful, that still does not redress the other actions, other organizations' actions. Judge would ask a very interesting question about traceability later on. I really enjoyed that question. So here, Judge, isn't that beyond the scope of 12B? And that you can argue that at summary judgment, and then they can argue that maybe you're all talking together and it's hard to, and maybe it is a traceability problem. So the judge is saying, so maybe when you all talk together, then we can't really trace who is the responsible party. FDA says, no, Your Honor, this is not a merits question. You should be saved for summary judgment. Standing is clearly jurisdictional, and it is clearly something that needs to be established for plaintiffs to make it past the 12B motion to dismiss stage. And plaintiffs have to allege facts that establish not only that it's possible that their injuries would be redressed by the order they are seeking, they have to establish that it's likely and they haven't met their burden to do so. So FDA is saying that even if you said what we said was not correct, that still would not reverse or fix the plaintiff's problem. Judge says, okay, my last question, which was from earlier, if you are correct, check this one out. If you are correct and courts do not have any role to play as long as the FDA is speaking informationally, then who or what would prevent or would correct if the agencies are giving out false information? This is a very interesting dialogue here. Judge is saying, okay, fine. You're saying that we have nothing to, we can't police, we cannot do anything. Who would do it? So check this out. If the agencies are giving out false information, and I'm not saying that there is false information here, that if you believe that the courts just are not well suited to it, or that the ultra various doctrine doesn't give it, then who does? FDA says, check this out. Your Honor, the FDA is politically accountable. They said, we are a political organization. We're politically accountable. Can you imagine this? FDA would be saying, that means FDA would be different under Trump and different under Biden and different under other presidents, other Democrats or Republicans. Is that what FDA is going to do? So they said, we are politically accountable. Your Honor, FDA is politically accountable just like all other executive agencies. And the government has to be able to speak to its constituents by conveying information in this way. Do you agree that FDA or other agencies should be politically accountable? I understand that the top heads may be put in place by politicians, but do you think that politics plays a role? So there is a democratic FDA when Democrats are in the administration, and then there is a Republican FDA when the Republicans are in the... So, Your Honor, the FDA is politically accountable, just like all other executive agencies, and the government has to be able to speak to its constituents by conveying information in this way. Judge says, how will they be held accountable? FDA says, they will be held accountable through the political process. So you have to go and elect. So they changed the FDA's head recently. Was there any election involved? So judge says, but we don't elect the FDA. And the FDA doesn't seem to adhere to the unitary executive doctrine, does it? So, how would it be politically accountable? Perhaps that's beyond the scope of this case. FDA, I do think it's beyond the scope of this case. But what is the answer? Judge says. And FDA says, public can elect its government officials, and FDA, like other government agencies, have politically accountable heads of the agency who are held accountable by the political process. So, Your Honor, ask the people to re-elect the government so they can re-elect the head of the FDA so that we can do something differently. I had never thought that they would say this. You know what they could have said better? We are monetarily accountable. We are influenced by others. So this is actually disingenuous to say we are politically accountable. They're actually hiding something else. Their influence is something else. And they're telling us to go elect some other officials. You know that it's not going to happen. So, but the public can elect its government officials, and FDA, like other government agencies, have politically accountable heads of the agency who are held accountable by the political process. It's not the role, check this out, it's not the role of the courts to fact check the FDA's scientific statements meant to further their mission to protect the public from dangerous uses of drugs. So yesterday, when we were talking about this hearing, they were telling the court that you cannot police us. Today, they're saying you cannot fact check us. Judge says, executive branch or judicial branch, then there was less audible. YouTube had transcribed it as executive branch, not the. So I think the judge was saying, is that how you make a change? So when the FDA lawyer said that we are politically accountable, the judge said the elections, is that how you make a change? And FDA said, yes, Your Honor. I cannot imagine this. That bureaucrats are saying, go change your. So that means if you didn't like what FDA did, go change your president so that he can do something, the new president, that would make them do better. I don't know. So FDA says, yes, Your Honor. Judge, thank you so much. FDA, thank you. If there are no further questions, we'd ask the court to affirm or adjourn, I believe. Judge, you have saved time for rebuttal. So judge said to the appellant's plaintiff's lawyer said, I'm sorry, Judge, I said you have saved time for rebuttal. And so now it's Dr. Marek and Dr. Apter and Borden's lawyer. So now he's doing a rebuttal. So he's saying, thank you. In response to your question earlier, Judge Eldred, about the ultra-vires exception of sovereign immunity, this court recently held in Feds for medical freedom on bonk and allowed an ultra-vires claim to proceed against the federal government that the underlying claim that was ultra-vires, and to be very clear, ultra-vires is not a waiver by Congress. The ultra-vires doctrine is not a waiver by conference. It's an exception of sovereign immunity. So the court does not need to look at the Congress for that waiver. Sovereign immunity does not apply. And even though this court has said in Danos that it is not necessarily the broadest waiver sovereign immunity, that doesn't change the fact that FDA had no authority here. So they said immunity or sovereign immunity or not, or the ultra-vires or not, FDA didn't have the authority of what they were saying. The district court spent a significant amount of time on this issue, and so we would ask the court to reach it as well. I would also like to point the court's attention to the Supreme Court's decision in DHSV Regent, where the court were very specifically said that, and check this out, this is Supreme Court now, that just as the people must turn square corners when they deal with the government, The government should turn square corners when dealing with the people. There is a degree of precision that's required, especially when an agency that claims scientific authority. What a beautiful thing he's saying. Remember that in this whole discussion, FDA was really not very scientific in their evidences. So the plaintiff's lawyer is saying that there is a degree of precision that is needed for an agency that says, I am a scientific agency or authority. They shouldn't be playing fast and loose. And so judge interrupted and said, what do you say to opposing counsel who said if a ruling in your favor, doctor's favor, would cause a great breakdown in the ability of the government to be able to help people avoid the opioid crisis or NyQuil thing that hurts children, that was the lidocaine, or teenagers? Plaintiff's lawyer says, the government is incorrect in that assertion. Again, the appellants in this case, the doctors, have not challenged FDA's ability to communicate when they've received adverse events reports. If they are receiving reports that opioids are causing these difficulties and then they said NyQuil is causing this harm, then they can report that they have received those adverse events and they have received a notice of those adverse events. It's when they step beyond that and start telling people how they should or should not be using approved drugs. They said, sure, FDA can say we are receiving reports of harm or benefit. They should not be stepping beyond that to say you should use it or not use it. Then the lawyer continues and says, it's also notable that the government's best exception is a NyQuil case, which is not a prescription drug from last year. Then the lawyer continues, the government also repeatedly cites its mission statement. This is a very interesting paragraph. He says that government also repeatedly cites its mission statement about making sure the drugs are safe and effective. That mission statement is nothing more than a mission statement. The operative provisions that actually authorize the agency to do anything are contained in the rest of the Federal Food and Drug and Cosmetic Act. They're saying this, we are making sure safe and effective. That is just a mission statement. The actual permissions of what they can do are in the remaining act. And check this out. The Supreme Court has been very clear that the mission statements are not freestanding authorization to do whatever they want. And so if the government, in ensuring that drugs are safe and effective, that process is through the new drug approval process. So he's saying that FDA keeps saying we are making sure it is safe and effective, and in that process they're doing this. They're saying that is not the way to do safe and effective. The way for the safe and effective is to go do your new drug approval process. Once you're done, you're done. Judge says, what about 375? Plaintiff's lawyer says 375B on publicity. Then he says, it says that the secretary may cause me to send any information of imminent danger or health or gross deception. I didn't understand this part, and it seems like a transcription issue. But I want to go here. Judge said, so they could publicize every single day if they had them adverse events reports with this particular drug, if they had them. I'm assuming that's assuming argument. I'm not emerging or affirming the drug. And that would be okay. That's not what you are. So judge is saying here that if they just kept saying every day that this drug is bad. Plaintiff says, the lawyer, there may be additional legal issues with something like that, but as far as this case is concerned, that's not what we are challenging. Then he says, we'd like to stress to the court that the doctors in this case are not asking this court to break new ground or to take significant leaps. The court in Aviales and Supreme Court and have to see for Standard Oil talk about how pretty much anything an agency does is going to be agency action that triggers the waiver of sovereign immunity in the APA. In Writers Guild, so this is very interesting part. In Writers Guild, this court recognized that an agency, by raising eyebrows or by job owning, can exercise agency action and to influence the public just by raising eyebrows, such statements. Similarly, in Trudeau and Jeffy, those are out of circuit cases, but again, they talk about how the waiver of sovereign immunity 702 was supposed to apply to anything that agency does. These cases are well established. And on finally, for the APA claim, the Tazzy case out of the DC Circuit is a great example. That's very similar to this, where an agency made a statement or an agency classified a drug as a carcinogen, and then the court relied upon how third-party groups will then pressure private entities because of this agency's non-binding action, or how it would trigger legal obligations by other entities that were not the agency itself. Isn't this interesting that the agency would do something which would cause then third parties to pressure private entities to do things? So judge says this, what I was saying in the beginning. So judge says, so is this how you defeat traceability? So in my opinion, she reached the point of understanding that how when FDA says there is no traceability, judge says, so here is the process that you just do a little wink, wink, nudge, nudge, and then the third parties start piling up on the private entities, and then private entities get pressured of doing whatever, and then the agency simply says, I didn't say anything. So judge says, so is this how you defeat traceability? Plaintiff's lawyer says, this is all for the waiver of sovereign immunity, Your Honor. As far as traceability is concerned, again, like the plaintiffs are not, or appellants in this case, are not asking the court to make big steps. So he did not bite on the traceability question. He simply said, we are just challenging the sovereign immunity part. Then he gives an example he says, in Department of Commerce versus New York, Supreme Court case, the Supreme Court said that if the predictable effect of the government action is the heart of the party's claim, then that is sufficient for traceability. So Supreme Court said that if there is a party who has a claim and the predictable effect is present, in this case, for example, FDA is making those statements, there is going to be a predictable effect. So you're saying that if the predictable effect is the heart of the party's claim, then that's sufficient for traceability, even if these actions of third parties are illogical or unlawful. The holding in the Department of Commerce, New York, was very broad. It's very clear that the predictable effect of the FDA's actions were to influence the ability to stop. And then judge said, your time is up. And then they said thanks to each other. So I think this last part was very interesting. That Supreme Court is saying that if there is a predictable effect, and that is what becomes the heart of a matter, then that is enough for traceability. And he's saying that here there was a predictable effect. So that is the end of this. The transcript was a little not accurate in some places. My apologies for that. There was actually the audio issues as well. So it's not just the AI. I tried to read some parts as well or hear them, and I had those issues. So this is it. We are done with this one for now. This was 8th August's recording that is present. My summary is that FDA simply said, number one, we cannot be traced. The harm cannot be traced back to us. Number two, even if you say part of our statements are illegal, the remaining part is still okay. Number three, we have not stepped on a doctor's authority to prescribe ivermectin for COVID. And number four, the court cannot police them, court cannot fact check them. Their statements are science, and the total science's proof was reports of hospitalizations. I was reading on X, the former Twitter, this morning. There was a passionate fight going on between somebody talking about a drug for COVID and a bunch of doctors piling on saying, where is your RCT? Where is your proof? Where is your your studies? And I was thinking, here FDA said we had reports of hospitalizations. That's it. Based on which they ran this whole machine. At least I think they ran the machine. They say, no, we did not. So they made this Rube Goldberg machine. And I'm sorry to Rube Goldberg because his machines were innocent and fun to do something fun. This was a machine that really had very bad outcomes. So that's what FDA was doing. So thank you very much. Have a nice weekend. Please please like, subscribe, and share. So far, these videos are not taken down. So far, this channel is not taken down. So far, so good. And I would see you next week with the next set of discussions. Thank you. And like, subscribe, and share. There are links in the description if you want to get access to Dr. Bean or if you want to support this work. Bye for now.